Hi,
I am John Mark.
I am Hannah,
And I am Ronel.
and we are the group for to present to you the continuation of Chapter 2, Section F and G, and the whole Chapter 3 of the Book of Claridides on Land Titles and Deeds.
That's right, Hannah. We have learned from the previous group about land titles. We learned about the basic concepts about public and private lands.
And the other modes of acquiring titles, private conveyance, and the governing laws on land registration.
Now we shall talk about land administration and the situs of executive power over disposition of public lands.
What is land administration? Land administration is the process of determining, recording, and disseminating information about tenure, values, and use of land when implementing land management policies. It encompasses major aspects such as land registration, cadastral survey, and land information systems. Basically, it concerned with the accounting and survey of land through specific activities like the following. In the Philippines, no less than 9 agencies and instrumentalities of the government are directly involved in land administration and management functions. These government agencies include
At present, the previously named agencies and units of the government are performing under their respective charters and legislative authorities the basic land administrative functions of: first, land surveys and mappings; second, land titling; and third, land registration. Notwithstanding that our laws prescribe the specific procedures to be observed especially on land titling and registration, these agencies failed to provide for an integrated system or framework that would buttress the different land administration functions performed by those agencies. This apparent lack of cohesion and integration has resulted to the different land agencies having their own sets of records, data and maps which have spawned erratic and oftentimes untrustworthy pieces of information being fed to their respective clientele. Among the several public officials charged with the various land administration functions,
it is the DENR Secretary who is regarded as the Chief Executive Officer duly empowered to carry out the provisions of the Public Land Act or CA 141, as amended. The power granted to the DENR Secretary by law regarding the disposition of public lands are all executive and administrative nature, such as granting of licenses, permits, leases and contracts, or approving, rejecting, reinstating or cancelling applications, or deciding conflicting applications.
which powers do not include the judicial power to decide controversies arising from civil or contractual relations between the litigants. However, the DENR Secretary and the various field officers of the DENR are by law considered to as quasi-judicial officers in the disposition of public lands. Decisions rendered by them is conclusive and not subject to be reviewed by courts with the force and binding effect of res judicator except when there is a manifest and grave abuse of discretion amounting to want of jurisdiction and there is a showing they were arrived at arbitrarily or in disregard of the evidence on record. In this case, they may be examined by the courts.
Hello everyone, Hannah here. I hope you learned a lot from John Mark's very informative discussion on land administration. Now we know what are the different government agencies and instrumentalities involved in the land administration and management and what their respective mandates or functions are. Now let us move on to property registration. The Land Registration Code or Presidential Decree Number 1529 as amended entitled, Amending and Codifying the Laws Relative to Registration of Property and for Other Purposes currently governs the rules and procedure on land registration in the Philippines.
So what is land registration?
Land registration is a system by which ownership of real property is established through the issuance of an official certificate indicating the name of the individual in whom such ownership is vested. Land titles are registered through statutory process called Torrens Title System under which land ownership can be readily ascertained without any need for repeated examinations of voluminous public records and resulting titles are generally secure and manageable. Good thing we have Torrens Title System. Just imagine if we don't.
Oh no!
But it is important to remember, registration does not correspond to title. Here are some cases for your reference. In the case of Li Texsheng versus Court of Appeals, the court held that, to repeat, registration is not the equivalent of title but is only the best evidence thereof. Title as a concept of ownership should not be confused with the certificate of title as evidence of such ownership although both are interchangeably used. In the case of Sejones versus CA, under the Torrens system, registration is the operative act which gives validity to the transfer or creates a lien upon the land. A person dealing with registered land is not required to go behind the register to determine the condition of the property. He is only charged with notice of the burdens on the property which are noted on the face of the register or certificate of title. Also in Republic versus CA. The Torrens system is not a means of acquiring titles to lands. It is merely a system of registration of titles to lands. Consequently, land erroneously included in a Torrens certificate of title is not necessarily acquired by the holder of such certificate. So what are the purposes of property and land registration law?
Ma'am.
Yes.
1. To ascertain once and for all the absolute title over a given landed property. 2. To make so far as it is possible a certificate of title issued by the court to the owner of the land the absolute proof of such title. 3. To quiet title to land and put a stop forever to any question of legality of title and 4. To decree that land title shall be final and irrevocable and undisputable as stated in the case of Benin versus Tuazon.
That is correct.
Sana all.
Let us now move on to the nature of registration proceedings. So just a quick review, what is an in rem jurisdiction and in rem proceedings?
In rem jurisdiction, power about or against the thing. It is a legal term describing the power a court may exercise over property, either real or personal, or its status, against a person over whom the court does not have in personam jurisdiction. Jurisdiction in rem assumes the property or status is the primary object of the action, rather than personal liabilities not necessarily associated with the property. In rem proceedings, when the object of the action is to bar indifferently all who might be minded to make an objection of any sort against the right sought to be established, and if anyone in the world has a right to be heard on the strength of alleging facts, which, if true, show an inconsistent interest.
Ma'am. So what is the authority of RTCs to hear and determine all questions?
Regional trial courts now have authority to act not only on applications for original registrations but also over all petitions filed after the original registration of title, with power to hear and determine all questions arising upon such applications or petitions as stated in the case of Association of Baptist Forward Evangelism versus First Baptist Church. Remember, under Presidential Decree No. 1529 Section 2, it stated, but there are also instances when cadastral or land registration cases may be heard by first-level courts in appellate jurisdiction.
Thank you, Hannah. As a continuation, the following are the distinction between RTS General and Limited Jurisdiction eliminated by the PD 1529. First, Section 2 of PD 1529 was eliminated to avoid multiplicity of suits. Second, the law conferred upon RTC the authority to act not only on application of original registration. And third, it also includes the authority to hear and determine all questions arising such application. The Land Registration Court (RTC) is no longer restrained by its former limited jurisdiction. Under the new amended law, the RTC is vested with power to hear and decide contentious and substantial issues. Section 19 of BP 129 confers in RTS jurisdiction on all civil actions which arises to or possession of real property or any interest therein. The purpose of the rule under Sec. 8 of PD 1529 is to avoid confusion and difficulty in tracing the origin of the entries in the registry. The following are the status of pre-existing land registration. That's all. Thank you.
Once again, thank you very much for your time. Hope that you enjoyed our presentation. I am John Mark B. Pestock, who presented Chapter 2 Section F and G.
I am Hannah Gandia, who presented the first part of Chapter 3.
And I am Ronel Filio, who presented the last part.
And we are the group number 4.
Saying thank you
And goodbye.